Jerks. Wow. Big day today in court. Motions happening. Aiden Carney in court. A filing that Mark Bederow co-wrote with attorney Tim Bradel was heard today for Aiden Carney. Yeah, we're going to talk about it tonight. We have attorney Mark Bederow here back on the show tonight. So I'm excited. I took a little time off and probably going to do the same most of the rest of this week. I have one big show planned on Sunday night, and then we're going to look at Trial 2.0 coming up this Tuesday, and then we're going to do a bunch of shows as usual. But tonight we have the big show. We haven't had him on for a couple weeks, and it's always exciting here. I'm not feeling too well. I got these allergies. I'm like dying. I'm sneezing. I'm coughing. So if I'm on mute, the over-under might be like 2 or 3 times on mute tonight. I'm trying to keep it at 0. But I am sneezing and coughing, so I'm not going to talk too much. But I am excited to be back just for tonight with attorney Mark Bederow to talk about this motion that he wrote. He got in. They tried to keep him out of the Karen Reed thing, and now he was kind of in, even though he wasn't part of the court proceedings today. What he wrote, the motion, it won today. It won, and it's very interesting what's going on here between attorney Hank Brennan and Bradel and Bederow and Aiden Carney today. It was like kind of a little spat. And I think you know who won. Let's bring him up. Attorney Mark Bederow, welcome back to the show. How you doing, sir?
Okay, how are you?
Good. You got the Irish on tonight.
Celtics.
Celtic Irish.
It's playoff season, so
it is playoff. When does this start? Is it already started, or when does the playoff start? Let's talk about that first.
They play Sunday night. Is their opening game against Orlando, and if they win that, the next round would presumably be the big one in terms of ticket pricing. That would be the Knicks, and then ideally Cleveland, and then the championship. So need 16 wins, and the first one hopefully comes Sunday.
Now, you talked about ticket pricing. How do you get your tickets? Are you a season ticket holder, or do you someone that buys the tickets?
I get them in all kinds of ways. I have, sometimes very good friends and clients who help out and show appreciation. Other times you get your own. You can always tell whether they're my own or someone else's, depending on where I'm sitting.
So I'm guessing the better seats are from the friends, maybe? Is that what you're trying to say?
Better seats come from knowing the right people, of course.
Yeah. Yes, absolutely. I get that totally. Amazing. So that's amazing that you get to go to Celtics like that, too. You must be thankful of that.
Yeah. We'll
see you there. Are you going to be at any of these games, these playoff games, you think?
Certainly some. We'll see when. Can't say that Sunday is an impossibility. Unclear. Really depends on a couple of moving parts, a couple things. We're supposed to be on vacation this week, out of town vacation instead of a staycation, but some work fire drill crisis came up that required staying home, so we're kind of in a staycation situation. So we'll see. Maybe depending on how a few things play out the rest of the week, maybe we'll get there this weekend. You never know.
Your life sounds like mine. And I have to stay home, even something came up.
Yeah,
it's different. Yours is higher stakes. I just have to take care of dogs.
Well, I mean, sometimes it's important, sometimes it's not. This is pretty important, but it would have to be in order to stay home and miss a trip. So,
yes. Yeah, someone says Kowloon. Oh, it's Mazza. Mazza's there. The 3 M's. He says Kowloons or Busberg.
If I go, there has to be a way to work.
We have to do a Kowloons. I still got those awards over here I got for you guys.
Leave
to get them to you guys.
Never know.
I don't get out much either. That's the thing. But I want to get out for that. So let's talk about this. This is why we're on the small screen right now. We got this filing, this motion. Is that what it's called? Because you guys aren't really a party of the case, but you became part of the case because your client, Aiden Carney, was going to be a witness in this case, which was going to require a sequestration
Right.
And that would silence his reporting and his journalism and him covering the case and being there at the trial. And he's like the #1 reporter on this case. He's the first one to really break it open. He's got so much experience of breaking big Mass State Police corruption stories in the past, even before Karen Read. So he wanted to be a part of this. Tell us about what happened today. What were your thoughts? Tell us everything about the filing, everything. What do you want to start?
I mean, the motion, which was filed at the end of March and really wasn't even docketed until the other day. Other people can speculate why that might be, maybe because of the contents of it. That's for others to decide. But the motion was filed. It contains a lot of grounds on why the client should not have been sequestered, separate and apart from the most obvious one, which clearly was always going to make him not have to testify, and which really demonstrates the absurdity of this whole process. But the idea of putting him on the witness list at all, certainly in our view by the prosecution, was just an absolute joke. It was never going to happen. They were never going to be serious about it. Clearly, at least from our perspective, and I think most reasonable observers, this was nothing more than a stunt or a gimmick designed to keep out of court. And more importantly is the sequestering. That's worse than keeping him out of court. That would be keeping out him from watching any of the proceedings, which by definition means you can't write about it, you can't do shows. And in essence, what you'd be talking about is somebody whose living is as a reporter, as a journalist, would be precluded from working literally for the better part of 2 months because of this concept, this nonsense that he could be a prosecution witness, and therefore, out of an abundance of caution, he ought to be sequestered. And again, because this was such an open and shut issue on Fifth Amendment grounds, which we can get into in a minute, a lot of the other issues that were addressed in this motion never really came out in court, which is fine, including a detailed presentation that this was a stunt. Now, you also have to recognize that we got notice that this was going to be argued today about 50 minutes before court started. Obviously, I'm not there. I'm not in town. I wasn't expecting to be anywhere. You get little short notice. It doesn't get docketed. So a lot of the stuff that's in this motion doesn't even get addressed. The bottom line is this. The DA's own obsession with Aiden, which has existed for years at this point, based upon their constant indicting him, seeking to indict him, arresting him, summonsing him, trying to have him thrown in jail, you could go on, worked against them. And obviously they should have known that from the start, that if they thought that he was going to testify in a way that was somehow going to establish that he and Karen conspired to commit witness intimidation such that his alleged conduct would be admissible against her to show her consciousness of guilt, which candidly, from my perspective, is a kind of silly, way down the rabbit hole concept, really out there. But putting that aside, what the DA was telling you is that we intend to examine him about things that we believe would be highly incriminating to him while he is already under indictment for literally the acts upon which they wish to question him, which would make his testimony, if he were to give any at Karen's trial, admissible against him at his own trial. And you see, they're not bashful about clipping video and, talking about statements of defendants. In Karen's case, they're, spending a lot of time on that. So then you add in the concept that from a few weeks ago, when they were going crazy, looking under every rock and crevice and in every crevice to find communications that they believe would help them demonstrate a conspiracy between the two people, Aiden and Karen, that as part of their filings in that, and this was the special prosecutor's filing, there was this subtle or not so subtle, as it were, footnote in which they represented, well, we're still investigating the possibility of indicting both of them for, witness intimidation, notwithstanding the fact that a grand jury had already determined that apparently there was too little ham in the sandwich to do it the first time. Putting that all in context, the idea that any lawyer, okay, even a real estate lawyer, even, anyone who's a real lawyer who doesn't come from the Twitter law school, the idea that any real lawyer would say, you should testify, okay? It doesn't matter what you think about how harmless or not harmless it is. The prosecution is telling you, we believe it's incriminating. We're going to use it against him. And when we try him, we're going to use all of this. It becomes very simple. You plead, you don't plead. You assert that you intend to plead the fifth if called. And now that puts the DA in an impossible position. Because Aiden is basically, Moby Dick to them. He's the great white whale that they just can't stop hunting. And at this point, Morrissey is, Captain Ahab, just trying to harpoon him any way he can. If he takes the fifth, and it's clearly a good faith basis to do so, which everyone recognizes, including Brennan, including the judge, including a fifth grader, would recognize that it would be a valid basis to take the fifth, that leaves the DA with only one way around that. The only way to get around the Fifth Amendment, assuming it's a valid claim, is to grant immunity. Now, if you think they're granting Aiden Carney immunity to testify about a bunch of nonsense against Karen Reed, it's not going to happen. It also tells you how really ticky-tack the case against Aiden was, because if the case, there's just no way that they were ever going to do that. Okay.
I'm laughing a few times because one of the things, like, it reminded me of the Wendy Murphy school of like, you have to put yourself on the stand, Karen Reed. It reminded me the same thing Brennan was doing with Aiden.
Wendy is a professor at the Twitter law school. And, a lot of the people who, take courses in turtle hatred will tell you, oh my God, this is a hiding behind the Fifth Amendment. If you assert a constitutional right to which you are entitled and you call that hiding, then you need to check yourself and understand how due process, the Constitution, the Bill of Rights works, and put yourself in that situation. It doesn't matter whether you think the charges against him are silly, they're ridiculous, they're overcharged. The bottom line is the DA is looking at you saying, we're going to use this against you. And if he testifies, they could misinterpret. And by the way, do you think that these prosecutors, based on what you've seen, would take liberties and possibly misinterpret and twist what's being said? I would suggest to you the answer is yes. So when faced with this, any lawyer, again, not from the Twitter law school, but with a real practice, would always advise a client, you don't do this. Okay, you don't do that. Now, the added bonus of that is once you realize there's no way they're ever going to immunize him, you're solving the other problem without anything else, which is if he ain't a witness, he ain't getting sequestered, right? So this litigation, if you can call it that, was always a joke, okay? It was never, ever going to be a situation, despite what people may think or assume the worst. There was never a situation in which he was ever going to be banned from the courtroom or more importantly, sequestered. And even putting him number one on the witness list doesn't do it, okay? None of that was ever going to matter. And there isn't any lawyer who would not do this. And that's the lawyers advising a client. And any lawyer who would not state the client's intent to take the fifth in these exact circumstances would have to call their malpractice carrier beforehand and get an opinion and say, am I covered for this? Because, I mean, I'm kidding, obviously, but that's how reckless and frankly stupid it would be to not do that. So when you see the online trolls and the Twitter law school graduates talking about, oh, you're just a coward, or we know what this means, and you see lawyers on court TV saying this, you see idiots in the attic saying this, you see other kind of long-term enemies of this guy saying this, it's just, all they're doing is confirming how profoundly ignorant they are.
It seems like that's the only reason they did it, so
course.
that they could say,
yeah.
And it's funny too, because I feel like you called his bluff today too. Like, in fact, like, because I think he was looking for the gotcha moment on the stand. He wanted Aiden to say, "Oh, I plead the fifth" on the stand with the cameras there, and it just today it was like, you know, especially he had to say why. Like, first of all, when he made his first statement, he's like, maybe we'll have him test. Like, you could tell he had no plan. Like, and it's so funny because you've been saying this for so long. You and Aiden, actually, both of you have been saying that he'll never testify. And I was more doubtful, actually. I was like worried about it. I believed you guys, but I was still worried about it because of this judge and this, you know, the way he's running. But today, you guys called this bluff today. It felt like, and like he got exposed. That's what it looks like to me. Like, am I right on that?
I guess you could say he got exposed because he looked silly at the end, which we can get to in a minute. But the reality is, the minute that they seriously said that we're going to call him as a witness and we're going to get him sequestered and we're going to, you know, silence his speech, people got all concerned, upset. But internally, amongst lawyers, this was always a joke. Because, again, contrary to what a lot of these people think, we've been doing this a long time. We actually understand how this works. We understand how the chess game is played and how when you move the queen here, they're going to move this. And it's very simple. Once you have a legitimate assertion of the Fifth Amendment or intent to take the Fifth Amendment in a case like this, which is totally legitimate based on what they're trying to do to him, at that point, the idea of sequestering him was over. Now, if they want to grant him immunity, then have at him. God bless you. Because here's the other thing, and this goes back to some of the other issues. You and I and everyone else knows they were never calling him as a witness. This was an absolute joke from the start. They're not going to call him as a witness to explain that he went up to one of their witnesses' faces and said things which are not really in dispute because, you know, they're in the record. And then he explains, well, yeah, I said that because I thought that person was involved in a crime and this. And then the question becomes, what the hell does this have to do with Karen Reed? Nothing. This was a stunt from the beginning. And by the way, a stunt not without precedent. This is not the first time he's done this. Okay, he did this in the Bulger case, or tried to do it in the Bulger case, and attempted to silence 3 reporters, including Howie Carr being one of them, who, as you can imagine, as you know, Howie Carr has been for decades probably the most vocal, at least in terms of reporters, critic of Whitey Bulger and the whole Bulger family. I think he literally wrote the book on what he would call the Bulger crime family or whatever. And
it was a hit. Whitey actually, at one point, allegedly sent someone by his house or something. Something happened. Yeah.
Well, that, you know, again, Whitey was a great man, we're told. But in any event, the point is, Howie and 2 other journalists were put down as defense witnesses in that case. Now, in all fairness, you know, Brendan was the junior lawyer on that case. So I'm not going to tell you it was his call, but, you know, he was part of that team. And the prosecution had to argue that this was improper and would violate his First Amendment rights to do this and that. This was in a federal case, obviously. And the federal court ruled, we're not sequestering these people. This is ridiculous. They don't really have anything to add. They have a First Amendment right to report on a matter of public concern. And certainly, going back to the current case, whether you like Aiden or you don't, which I understand is an open question depending on who you're speaking to, not really the point. The point is, he covers the case on a regular basis. He's written 500 articles or thereabouts on this. He does these shows that are very popular, as you know, about this. Certainly during trial, the numbers go up. They're more frequent. I mean, people turn to him for, he knows the case better than almost anyone factually. Again, whether you agree or disagree with any of this, I don't really care. The point is, you have a right to make a living. And when your living literally involves the First Amendment, you can't just be throwing people out of the courtroom because a DA says, well, I might call it. And that's what you heard today. It's very interesting. I might call.
It
I don't know. Depends.
Depends on how it goes. That's basically what it's.
Well, that's a lot of humada. The bottom line is this. They're going to call him blind without speaking to him to what? To say what? To say that you went to a lacrosse game and you accused one of our witnesses. And again, I'm just speaking what's in the record. He accused one of our witnesses of being involved in a crime, as opposed to Karen being involved in the crime. And somehow that's going to translate to, well, in that case, ladies and gentlemen of the jury, Karen's guilty. I mean, this was always the kind of thing that, was never going to happen. And there were other issues too. I mean, I don't think this ever got addressed by Karen's team, but, given the fact that they said that they're both under investigation, okay, and in essence, if Aiden were to testify, he could be testifying about uncharged crimes of Karen's, allegedly, if you believe what the DA is saying, for which she's being actively investigated. And there are admissibility issues about whether they should be allowed to use as bad acts against her, and she doesn't testify, presuming that's the case, these uncharged crimes to kind of smear her. So all of this was just from the jump.
Doesn't seem
fair. No, none of this was ever going to happen is really the point. And everybody knows that.
So saying that, I'm imagining, because now I'm wondering, like, I think Hanky got the best he's going to get today now. Because, like, I still wonder, like, if he's going to try to use, like, oh, Turtle Boy pleaded the fifth.
But you can't.
He can't.
No, you can't. I mean, that's, again, what,
no way to admit it. Yeah, you're right. Like,
necessarily teach that at the, Twitter law school. You have a constitutional right against self-incrimination, and, inferences should not be drawn. Now, when it's a witness, it can be a little different, but Massachusetts is different. It's off limits. Okay. And this came up in the first trial when there was discussion about, well, what if Proctor were to take the fifth? What does the defense do with that? And the answer would have been nothing. I mean, they could talk about all the things he did in the investigation, and then the jury determines, well, where the hell is this guy? But what the defense was not going to be able to do was say, that guy took the fifth, that guy took the fifth. The worst part is these assertions of the fifth, or at least the judge being satisfied based upon the representation of counsel that the client is going to take the fifth, which we said in the motion, which Tim reiterated today in court, usually will settle it, but not in this case, right? I mean, you saw this very petty stunt again about, I want to get him up there and hear him say it when he knows what he's going to say. And that's purely for the television audience and maybe to please some other people who have a vested interest in just hating the client for whatever reason. And, the judge rightfully recognized after a break, I'm not doing that, because that's just not the way it is. And I'll tell you, normally there is a code amongst lawyers, okay? Amongst, gentlemen and gentle lady lawyers, that there are things you do and you don't do. And all I can tell you is when the lawyers who've been doing this a long time at a high level put it in a motion, the client will assert the fifth. And then they come to court and assert that again and say, I will, Your Honor, as you heard Tim say. And the response of the DA is, The DA, not the defense attorney. Usually you think these things would be on the other foot. You don't usually see prosecutors do this. Say, no, 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 I want to hear it. And it takes the judge to say, I'm not going to do that. There is something really off about this whole dynamic, this whole manner of prosecution, this whole aggressiveness, this whole pettiness, this whole way of, complaining about what gets made public, but trying to get as much public as you can in the courtroom. So say, hey, it's in the courtroom, so it's fair. It was a bad look.
Bad. I mean, it's pretty blatant if you're watching it too. Like anyone that's watching this, I feel like if you just watched, like most people, they don't need to watch even Turtle Boy or my show or any of these shows. If they just watch what's going on in court, they see what's going on. Like never, and then they start listening to the shows. I mean, that's all they need. It's just, you can see it. It's very obvious.
This was an unnecessary spectacle that was designed as a stunt and maybe a Hail Mary that they were praying from their perspective that he's so reckless and so uncontrollable and so egomaniacal. This is their perception that notwithstanding the lawyers, this guy's going to just do it because he can, and it will make great theater and we'll get him. And the idea that that was ever going to happen is about, I'd say the same odds as, the Brooklyn Nets winning the NBA championship, which of course the odds is 0. So
Nets have no chance. They never have a chance. I've never heard the Nets ever,
no,
right? I mean, have they?
Well, if you're a Celtics fan, you should really thank the Brooklyn Nets for Tatum and Brown. Really, they took your old, retired, washed up stars from a generation ago, thinking they still had anything left in the tank when they didn't, and traded a bunch of draft picks, which became Tatum and Brown. So we should go easy on the Brooklyn Nets.
Thank you, Nets. People, I am sick tonight. People should know. It's not like a cold, though. I think it's the allergies. Mark was giving me all kinds of advice earlier before the show on how to battle these things. I'm gonna get some. I got some suggestions. Hopefully, I'll feel better soon.
Allegra D, miracle.
Allegra D. I got it written down. Allegra D. What is it? 245 or something? What did you say?
Allegra D 24. You got to get.
That's right. 24.
All right. D. Make sure it's D. Allegra, regular or Allegra is useless. Allegra D, and you want 24. It's
Allegra D.
4 hours.
I'm getting a D. I'll be getting that tonight. And there we go. They know.
Yep. It's behind the counter at the pharmacy, and you can thank Walter White for that, for the Breaking Bad people. Years ago.
So I gotta ask for it.
This kind of
real stuff
is used in like meth cooking and that, and they're when that became a big show, it became a problem, and now you can't get Allegra D 24.
I need it. That's what I need. I got my ID. I'm gonna go to the 24-hour place down the street. I'll be hitting that.
You'll be good.
I'll do anything to get rid of this.
You'll be good.
I thought I got all the meds. I went to the store already today and bought like a shitload, but
no,
I need this stuff. I'm getting the Allegra D. I'm gonna try it.
Yep.
So this is amazing because I'd like to see this today. This was just, to me, this was exciting. The best part of it was at the end because there was this whole hearing, and then the Turtle Boy, Radel. It was like so exciting to see it, and then just to see him, like he had nothing. It was just such a joke, and the trolls are like so excited. They think like they got Turtle Boy because he pleaded the fifth, and I just sitting there like, are you kidding me? Nothing. There's nothing going on here except that. It was just a moment to give the trolls an opportunity to be excited about something because this guy has nothing. I feel like this retrial is not going to go better. I've just already seen it. Am I right on this? What do you think?
Well, let me start with this. Anyone who is excited or was excited or is trying to spin this, he's going to take the fifth, so that means something. First and foremost, that's just profoundly stupid. Second, I pity you because you really should learn about your constitutional rights and be more informed and educated. because certainly when you look at some of these trolls, it could happen to them at any moment. But beyond that, I mean, that is part of the Bill of Rights. Okay, asserting a constitutional right is a right that anyone is entitled to do. It shouldn't be read into. I mean, these are the same people. Oh my God, someone's coming after me, rightfully or wrongfully, so I consulted a lawyer. Well, if you got a lawyer, you're guilty. If you take the fifth, you must be guilty. If you don't consent to a search in your home, you must be guilty. No, there's a reason why the Bill of Rights are there, to protect people from government abuse. Okay, and anybody who thinks that if anybody were to testify in Norfolk County in a case like this, that there's no risk that, even if innocent, that those words could be spun, twisted, manipulated, then my advice to you is watch all the pretrial hearings in Karen's case for the past few months and ask yourself, is that really the case? Whether you think she's guilty or not. So I'm not sure why they think that this is such a big thing. This was always the obvious way of handling this, and it has nothing to do with the client. That's the client recognizing and trusting the advice of experienced lawyers, which 100 out of 100 criminal defense attorneys would give the same advice. It's that open and shut. It's that obvious. It has nothing to do with guilt or non-guilt. It has to do about zealously protecting a client's rights against, an overzealous and aggressive prosecutor. It's not that complicated. It's actually quite simple. My only regret is every time something good happens in this case, I'm never there, because either stuck with obligations here, or there isn't even enough notice to even get there. The same with the phone records from a couple of weeks ago. That was like 1 day notice, and it's tough to just show up when you have your own schedule.
He found out basically this morning, from what Aiden said on his Twitter.
Yeah, I mean, you're always wondering, like, they picked a jury. I mean, you got to do this, and today seemed like the obvious day because they had motions scheduled. But when you don't know, right? So there's always that nervousness, or maybe that's not the right word, but this, you really want to know what's going on. You get anxious to figure out what's happening, and you wonder, why doesn't this thing get docketed for 2 weeks? Now, there can be any number of reasons, but some might think, well, we don't want people to read this and see what it says. Another could be because they're on trial and they're busy. I mean, it's whatever. The bottom line was, this was always going to be a formality, and anybody who thought different just doesn't understand how this game is played.
I could see it clearly now, especially knowing that Aiden would plead the fifth. I wasn't sure he would actually do that. But he did, and it's like, it's an easy out. It makes sense. The best outcome too.
Yeah, but again, people can take the fifth without being guilty. Again, it's just words.
Why not protect your rights, especially knowing they're so against him? He's got so much on his plate. It does nothing. Like, in terms
if you had all of these people online or in public who were saying, oh, you just did this because you're guilty, and you have these lawyers on court TV, which is really disgraceful, suggesting we know why they did it. If you took all those people and multiplied that by the vast majority of the population who thought that, you'd be living in a totalitarian, tyranny-filled, dystopian state where your rights are meaningless. And it's just shocking to hear so much ignorance and criticism towards people who validly, on advice of counsel, assert their rights. Not a privilege. It is a constitutional right that we all have. And it's something that people should do. And that's why people should consult lawyers. And that doesn't make you guilty either if you just consult.
I mean, when you're up on charges, it's like, you want me to do you a favor now? You've charged me, and now you're trying to get me in, and you want to put me at risk. It's like, you'd be crazy to show up and answer questions for Hank Brennan, knowing that you don't have to, considering that you're facing charges. And I love what you said too. Like, not hey, you want him to testify now? Give
Listen,
him a part. Give him a deal. Give him a deal. Give Aiden a deal. Let's see him offer Aiden immunity.
they are so interested in how important his testimony is, okay, to show Karen Reed's guilt. And, Karen is charged with murder. So, and this is like the biggest case in the country at the moment. So we understand that's the goal of the exercise. There's a simple remedy: give him immunity. But you know what? They're not going to do that because he is the Moby Dick of this exercise. And also, they do recognize, you know what? His testimony is virtually worthless. It's just a stunt. It always has been. And if they really, honest to God, thought that he had something valuable to honor, then you might say, well, you know what? A prosecution for, calling somebody a bad name and them saying their feelings were hurt is much less important than, bagging an alleged murderer. Okay. And they could have done that. They chose not to. Okay. Now, to be honest with you, this office is such a mess. I don't even know that Brennan would be authorized to, because they need a special prosecutor that's not him, because they're conflicted out, because they're so obsessed with getting Moby Dick that they need special prosecutors, but not special police, because the state police do whatever the hell they want, obviously. But that just tells you what an overall incestuous shit show this has always been. But this issue that we're talking about was never going to be a thing. And they had to have known that.
Funny too, because let's pretend he didn't plead the fifth. Let's just pretend for a moment that Aiden was like so wild that he wasn't going to listen to his legal counsel. He was going to. I still don't know if it would have turned out good for Brennan. Like if Aiden was actually answering questions. Brennan, because I just think Aiden would have been so freaking strong. Like I still even think that would have been dangerous for them.
Well, but go back a couple levels. What does it tell you about a prosecution? Forget the fifth. Play out the hypothetical. We're going to call this guy as a witness, and he has no privilege to assert, so it's up to us as the DA to do it. This is a witness they're never going to prep. They're never going to speak to. They're never going to get a chance to know what he says. And just to put this in context, if you remember at the first trial, you had a judge who's looking at the defense saying, you're going to call these ARCA witnesses without even ever talking to them, as if that was like, wow, you can't be that reckless. Now you think that's reckless. Put that in if you're Brennan calling Aiden to talk about his interactions with witnesses against Karen. Most importantly, again, they're trying to prove that somehow this conduct shows Karen's consciousness of guilt. His consciousness of guilt or conduct is not relevant to the jury because the jury's considering Karen's. And he's a prosecution witness, by the way, and that's really important, okay? And, Brennan's not stupid. He's not going to get to call him as a hostile witness. You want him, you call him. You're going to have to ask him open questions, non-leading. Now, how do you think that would turn out? That would be, that might make great TV and all that. But the point is, only an insane prosecutor would ever be so reckless and so desperate to run that risk for the possible reward of, I'm going to be able to argue that what he did shows that Karen's got conscious guilt. This is a joke, okay? This has always been a joke. Just the whole concept of this has always been a joke.
Like what Turtle Boy just posted in the chat. He says, if you need to prove that John O'Keefe was hit by a car, you don't have a strong case. If you need Turtle Boy for that. That's.
What I can tell you is this. If they're trying to prove her guilt on the, obviously that, she caused a car accident, that whether intentional or not, or reckless, whichever crime you think applies, if they're obsessing over evidence of establishing her consciousness of guilt because she spoke to a journalist and a journalist at some point spoke to witnesses in a way that hurt the witnesses' feelings, allegedly, and then they're going to come back and say this is powerful evidence, it shows her consciousness of guilt. First of all, if I'm the judge, I don't even know if I'm allowing that. I would be very concerned that that is so attenuated, so far out there, too prejudicial. You know, any probative value that it might have would be substantially outweighed by the prejudice. I thought this at the first trial when they allowed some of this, but of course, at the time, the judge said you can't use it against her, right? It was just to show the witnesses, you know, whatever. You can't, you know, hold this against Karen. But if you're not going to hold it against Karen, there's no point for this. So this is a bizarre thing for them to focus on. But what they appear to be focused on are this and turning themselves into pretzels, logically speaking, about whether they do or don't want the ARCA people to testify and whether, you know, this is fair or unfair. And what they're really telling you is they're terrified of it. And they recognize that I would imagine that the defense tactically is going to change their strategic emphasis at the second trial, and that they're desperately, notwithstanding what they tell you, again, you know, do you take them at face value? Oh, we welcome ARCA. No, they don't. Every chance they get, they bitch and moan and whine and have a tantrum about why they shouldn't be allowed to do this and why they're not getting evidence and, you know, doing all of these things that, I mean, if I understood today correctly, the concern is how dare the ARCA guys have any opinion that is anything else than within the four corners of their original report. Now, let me tell you something, the way lawyers work, this is not rocket science. The DA knows what the ARCA report is, and they know if it's credible, they're done. I mean, that's just the bottom line. If the jury thinks that it's a possibility that those guys are reasonably accurate and that, you know, there was no car accident, then the case is over. And anyone who tells you that that's not the case, ignore them. That's reasonable doubt if you credit that. So obviously these guys are important. So Brennan decides, I got away with it the first time somehow, some way. I don't know what the jury did or didn't do. I don't really care at this point. But the bottom line is they used this Trooper Paul guy who, I mean, was outclassed, obviously, and that's being charitable to him. I mean, he was, you know, pretty much the worst so-called expert you would ever see in a courtroom. So he went out and got this Welchler firm or guy or firm to get real analysis in his mind, again, for their case, to show that it was a car accident, which is fine. That's what you do. But is it all that surprising that the defense reaction to that would be, okay, our guys say this, their guy says that. Now I need to take their guy's report, show it to my guy, have them tell me what's going on here. Am I worried? Is there anything different? Has your opinion changed? Are you still with us? Can you explain to me this or that? So obviously the defense is in a position where, in addition to having ARCA give their testimony in terms of their own evaluation, they want them to be in a position to address Welcher's report and attack it. And you saw that at the first trial with the cell phone stuff, I think, if I recall correctly. You know, you saw DA witnesses talk about reading reports of Richard Green or whoever. This is common. This is not rocket science. And what you have is the DA basically throwing a temper tantrum, you know, literally a week before opening statement, saying they can't do this. They're not allowed to do anything beyond the four corners because they're sandbagging us. Now, this is rich for two reasons. Number one, of course, the defense is going to have the ARCA people take a look at it. And if able, they're going to want to do that. Number two, you saw once again the master gaslighting about, you know, a temper tantrum that the central component of which was, we're getting sandbagged by the defense. They're violating all these discovery things. They're doing this on purpose. And these are the people who literally drip, drip, drip the Sally Port video. They turn it, before, during, and after trial. They still are doing notice of discovery. I mean, even right now, it comes out a few weeks ago that it turns out their position is that the Sally Port video was in Proctor's back pocket for 2 years and nobody knew, but that's okay. But goddamn, the defense better not, get this information, go to the feds, file another TUI, line up these people, and do the best they can with the timeline that they were given, which was less than 2 months ago or thereabouts. And the DA is having a tantrum saying the jury can't hear this. Now, that's usually, again, in a case, usually it's the defense in any given case that would have a tantrum about the prosecution is overbearing, okay? But they are just operating in a way where they believe they have a right to do it their way or the highway, and discovery violations only go one way, and we're going to do anything and everything in our power to not let the jury hear anything that just might persuade them that she's not guilty.
That's it. No evidence. Karen Regan gets to present no evidence, no defense, and they have discovery issues throughout this whole thing. There's still no metadata on the videos that they wanted. It's just like you said, new videos coming out. Even with the police audit, there's discrepancies between the police audit and what we heard in court in terms of the video filings and things like that. So there's so much BS going on with this prosecution, and for them to turn around and say, no, it's the defense that's doing that. The defense.
They just got the report in early February. It's now early April. Okay. They have to go through the TUI process. They have to review the report themselves. They presumably have to show it to the ARCA people, and they either get a report or they don't. But either way, this guy is saying they can't go beyond their report from a few years ago. And that's because, I say so. That's just not how a trial works. I mean, it's not fundamentally fair. And, you see this all the time, okay? Whether they use these actual words or not, this prosecution always tries to put themselves on the same plane as Karen in terms of what a fair trial is. And it's not the same. I mean, and, we could beat this to death every time we do this, but it bears repeating. She has a constitutional right to a fair trial and due process, which includes, a right to present a defense. Now, that doesn't mean that any judge should ever just screw the prosecution from doing things. But when you have close calls, the tie goes to the one that has a constitutional right, which is here, than, the DA's so-called right to a fair trial, which is here. It's not here, but it's not here either. And the idea of them just whining all the time in this insufferable way about we need to have a fair trial and the defense is not being candid and they're not doing this. I mean, it really does feel like Bizarro World. I mean, they have a right to put on a defense and they have a right to do it. And I think you heard them trying to basically say some of that today about what do you want from us? Okay, we are obligated to do this. Okay, that's code word for our job is to present a credible and vigorous defense for a client who has pleaded not guilty. And the way the Constitution works is she's presumed innocent unless and until they, establish beyond a reasonable doubt. If part of that evidence is not only the ARCA people saying that the car and John O'Keefe's body are not, incongruence in terms of the prosecution theory, another part of that is the DA's claim that it is wrong, and here's why. Assuming they can say that, I don't even know what they will do or not do. But the idea that the prosecution is going to get up and have a temper tantrum in court and say this is not fair, that they are allowed to go beyond the four corners of their report it's bonkers. I mean, this is like, you don't see this on a regular basis, and you virtually never, ever see this coming from the prosecution.
Judge did just rule on that. Did you see the ruling on it? She made a ruling on it about.
Yeah, I mean, I saw something along the lines of, I'm putting deadlines for the defense to tell me what's going on, and then you guys can complain all you want. She can't deny this. I mean, if the ARCA guys have a strong opinion, and they're credible and qualified, but if they are willing to give an opinion that says Welcher is wrong and here's why, they're allowed to do it, assuming they're qualified to give such an opinion. And that's that. And I understand why the DA doesn't like it, because again, if ARCA is credible, it's over. And the burden that the prosecution has is they can't win a case where the jury says, well, the ARCA guys are credible. You know, I get what they're saying, but I get what Welcher is saying too. That's by definition reasonable doubt. That's a reason for which you could give in which she's not guilty, because the ARCA guys make sense. They could be right. The DA has to basically establish that the ARCA witnesses are entirely not credible, that they're just not believable. And you know how desperate they are in this task, because they've kind of shown their hand when they talk about, well, you know, they got $20,000 for expenses after the first trial, or, you know, one of the guys sent an email to Alan saying, these are the questions, as if this somehow is going to invalidate their opinion and somehow discredit them. That's what you call flailing. That's not good when you're the prosecution, and that's your best argument to undermine a defense expert.
Shows how weak their case is. Totally.
Yeah.
Question from Mr. Meathook. They say, but Bederow, in all candor, doesn't pleading the fifth plant a bit of a poison seed in the mind of the jury?
Jury's never going to know. They're not going to know that Aiden or any other way. They wouldn't know if Michael Proctor took the fifth. I would suggest that would be much more powerful, given, you know, what he's involved in and what was found out about him, than Aiden. No, the jury will not be told that any of those witnesses took the fifth, the same way they're not going to be told if Karen doesn't testify. In fact, to the contrary, they would be instructed, if the defense so sought, that they are not to draw any inference whatsoever against her because she exercised her absolute right not to testify. I mean, there's a reason why these are constitutional rights. Where'd you go?
I had to mute myself and blow my nose and was sneezing, you know. Doing a show and you have these allergies. I didn't want to cancel. You know, I don't cancel. I keep working. We'll get through. We're fine. We're doing good, right, Mark?
You're doing good. The other thing you saw today, which I think is very interesting, the DA is just outgunned. I mean, I'm talking manpower. The prosecution team appears to consist of Brennan and two potted plants. Okay. The defense team is, using four lawyers on any given issue to do certain things and come at you with this, and this person focuses on that. This one's doing that. There's a division of labor. There's just better rhythm in what they're doing. And this appears to be just against a one-man show. And then there's window dressing from the first trial. Now, maybe that will change. Frankly, I think they're making a mistake by not having the other prosecutors involved in more, action in the courtroom, because it's just a lot to do, a lot to think about. And, it might be also beneficial for the jury to just get a break from him once in a while and hear a different voice and just get out of that, 2 months of that same delivery. It's human nature to just want a little change, in things. It makes it more interesting. So, I thought that was very noticeable today. You had, 4 lawyers doing this, doing that, and just one guy who's taken it all. He's taken all the shrapnel. And, over the course of 2.5 months, those body blows add up.
It's interesting. Like you'd think they might spread it around just even a little bit. You think the other two are barred? Like they're, just sitting there, not gonna use them at all?
I don't know. I mean, they know the case. They tried it once already.
Yeah.
But, even during the motions to dismiss, when they could have had, a lot of knowledge about what happened, they just sat there staring at the back of the judge's bench. I don't know. I mean, look, optics can be everything. And one of the unfortunate things, or fortunate, depending on, what happens in this case, is that it's always on video. And there was, somebody posted video. I didn't see any of this live. I've literally seen none of this trial live yet. But on one of the days of jury selection, when they were introducing themselves, that like Lally literally did not react. I mean, he literally did not introduce himself. He did not nod. He did not say, good morning, ladies and gentlemen, anything. And that is an egregious failure of a trial lawyer. I mean, the idea of literally sending a body language message to prospective jurors, some of whom may in fact be on the jury, I don't know, that I don't really give a shit. I don't want to be here. I don't like this guy next to me who's talking my name, and I'm not even saying my own name. And I don't even have enough respect for you or myself to say, my name is Adam Lally. Good morning, members, of the prospective jury, ladies and gentlemen, however the hell you want to do it. That was stunning to me, to actually see that there was just such a lack of wanting to be there in a case like this, knowing the cameras are there. And I mean, to some extent, I don't blame him. He's been through this rodeo already. But the fact of the matter is, you are in front of the prospective jurors. You have to, you're on set, you're on camera.
You have to present. Yeah.
What message are you sending? What message are you sending the jury when you're standing there with terrible posture, like a lump of coal, and not even acknowledging them after you're introduced? I mean, not even a head nod, like no visible reaction or verbal introduction. That was telling. I mean, so is that the kind of guy, if you're the DA, you want participating in examining witnesses? Probably not. I don't know the dynamic, but I saw that video and that was really stunning.
We have a few questions come in.
Yeah.
This is one I want to ask. Well, here's one. We'll do with this one first. There's two. Mark, why aren't they appealing you being on the team? I think we addressed this in the last show, but it keeps coming up. I keep hearing this on social media too. You want to answer this one again?
First of all, it's not my call. I mean, it's not my position to do that. Second of all, I think it's just bad timing. It's late. It's late in the game. This whole concept of my addition was very late in the game. If this was 6 months ago, maybe it's a different situation, but I think that it's just too late. There's too much to do. And, at that point also, you can't rely on, hypothetically, say this guy's going to do, these 20 witnesses, but we don't know. Like, how do you plan? You need to know. And at some point, you just have to say it is what it is, whether you agree with it or not. But we got to look ahead. We got a woman, we think is innocent on trial for her life, and we can't hedge on what may or may not happen. I mean, what do you do for preparation? I think it just becomes too hard a task.
Too much that needs to be done too, right? Yeah. I mean, they've been filing away all these filings and hearings, and
yep,
yeah, like you said, it's a team. They got to go forward. They got to know who's doing what. There's a trial starting this week, so that totally makes sense. I hope that puts it to bed, because people keep asking that question. I know everyone wants you on the case. I do too, but
Me too. I mean, whatever. I mean,
Right?
it is what it is. It didn't happen. So what are you going to do? You can cry about it or you move on.
There's one that definitely concerns your client. Any updates on the motion to dismiss for Aiden? It's been a long
Nope.
time.
No update. Is it a long time? I mean, in my experience, complicated motions to dismiss can take 6, 7 weeks. It's 18 counts. Each one has to be evaluated independently. If you recall from the hearing, this was a judge who was very well prepared. I want to talk about count 5, 8, 10, 13. I mean, so this is obviously a guy taking it very seriously. I don't read into it one way or the other. I mean, if there was a decision, within 4 days, I would say that that's a bad sign. I mean, how could that possibly be? Because not only do you have to have a ruling, but you have to have rationale. I mean, you need an opinion in a case like this, for possible appellate determinations one way or the other. So I don't read into it at all. I mean, I think it's actually, in my experience, totally
On
normal.
track.
Yeah.
Good. Well, it's probably a good sign, actually.
I don't know. I mean, I truly
Yeah.
just don't view the time without more as tilting one way or the other. I don't, to me, it's right within the wheelhouse of time that it should be.
There's a couple more that came in too. Here's one that we highlighted earlier. Here it is. From Glenda. She says, how can the defense ascertain there will be no witness tampering during the trial? McAlberts and Commonwealth probably know everyone or know someone against Karen.
I mean, there's, in a free society, there's no way to know. I mean, you can't lock people up. You're not going to sequester witnesses other than telling them not watch the rest of the trial, but you're not going to like lock them and, wrap them up in saran wrap and hide them away in a closet until it's their turn. You hope that would never be the case. Of course, everything is mostly abnormal as it relates to this case. Who knows how anything's going to work? I mean, all the witnesses are supposed to be sequestered. They're not supposed to know anything about the case. They're not supposed to watch it or have any idea. Now, what would a cynic say about the prosecution witnesses? Do you really think some of whom live with each other are all closely related, either formally or informally, knowing what's going on? I mean, are they really, truly sequestering themselves? You hope so. That's what they're supposed to do. Same with the defense witnesses. But does anybody really do it?
I mean, it's Michael Proctor didn't do it, right? I mean,
Clearly. I mean, probably not. I mean, I think a lot of them probably didn't do it. I mean, you had all kinds of oddities going on at the first trial. I mean, you had the prosecutor, if I recall correctly, talking to a witness at lunch who was still on the stand. That's insane. I mean, once the witness starts testifying, in most jurisdictions, they call it just the rule. It's well known that that witness is on their own, other than a defendant who has a right to counsel. They're on their own. And, you had Lally talking to, I think it was Brian Albert over lunch when he was on cross-examination. I mean, that's just like the most obvious no-no. And my recollection is when this was brought up to the court's view is like, well, I don't know, I've never really heard of that one way or the other. And I'm, again, come from a different lawyer culture than here. But that to me was like the most obvious. You've got to be kidding me that the prosecutor thought it was permissible to talk to a witness of his while he's under cross-examination about the case. That is the most obvious. You don't do that. And apparently, at the time anyway, in Norfolk County, that's just the way things are done. I don't know. So
Jake at Chinatown.
oh,
I mean, it's so funny because it just keeps you think like that was one of the prosecution filings about how witnesses were changing testimony based on discovery that the defense gave the prosecution. I mean, it seems like it's not just like, coincidence stuff. It's like the plan. It's
Now,
kind of what
there
they've
are
been doing it.
there are things that happened about those kind of shenanigans in the first trial, which again, it's stunning to me that, and some of this was addressed in the motion to dismiss, that it wouldn't be more shocking and outrageous and require a deeper dive by a court to say what's going on here. I mean, you have this whole thing where one of the witnesses met with Lank, and we all know about that. And Tully took a report, and he held that report. He held that report, which could have been very impactful for more witnesses than just that one. Okay, it could have impacted the cross-examination of numerous other witnesses, including Jennifer McCabe, the obvious one, including Lank. And the prosecutor just inexplicably held that until they were all off the stand and then said, here you go. And apparently that's not a big deal. Now, in all fairness, at least as it relates to Jennifer McCabe at the time, the judge said, do you want to recall her? And they said no. I mean, in all fairness, that was offered, but that's not, even that is a weak remedy, okay, to recall her. Now she knows what's coming. It's all been contrived. She's studied, like she testified, she did all the other stuff. I mean, the idea that they just don't turn over that at the right time is just another example of just, how the game, at least last year, was played in that county. And nobody gives a shit. And it's just kind of surprising to me. It's just kind of like, that's how we do things. It's surprising.
It does seem like that. It's
yeah.
We'll just offer you this little lot. We'll give you this. We'll give you that. We'll make up for it. We'll give you that. Yeah. And you don't even, want it or need it. But
there's no rhyme or reason. I mean, even when the video was getting disclosed piecemeal, everyone's just looking, oh, here's the video. And, well, it's what's for lunch, this is fine. It's not fine.
It's like the Merritt video. I mean, remember the Merritt video? We all freaked out. We were like, this is it. This is it. Tomorrow is the day. Bev's going to lay it down on them. This is the moment.
That was a mistrial to me. I think in many jurisdictions,
yeah.
That was an absolute mistrial. First of all, you're talking about evidence that was disclosed in the middle of trial. That's bad enough. But then you're talking about false testimony, giving the jury the wrong impression. It's clearly material because it's got the wrong taillight, posing as the right taillight. It's hiding Proctor. I could go on and on and on. And they get sandbagged with this. I would have expected, I mean, in my own experience, a judge to just take a prosecutor to the carpet on that and say, pardon my French, but are you fucking kidding me? What are you doing? This is like, in a case like this, you certified compliance months ago, you did this, and then you go through this charade of having this witness basically lie about what the video, represents, and then it's okay, you'll be allowed to cross-examine. And what happened on cross-examination on that video, by the way? He got amnesia. He said, oh, yeah, it is inverted, but it's still accurate. And now I'm not sure that's me. I'm not sure that's Proctor. That's not good enough. That's not substantial enough. I'm sure they're going to deal with that this time around in a more aggressive way. But, they didn't have a chance to prep for that the first time, really.
Sure, this time it's going to be different. I wonder about this witness right here, the Dighton cop, Nick Barrows. Should the defense ask more questions of him this time? Should they go deeper with him? What do you think? Because it could be risky. I don't know if he's talked to the defense. We have no idea. What do you think on this one with the Dighton cop?
Well, it depends. I mean, the first rule of cross-examination is, should I do it or not? And, I think there are other witnesses that perhaps should have been cross-examined. I don't know about this one, though, because his direct testimony was entirely contradictory of the DA's case. And he was a DA witness. Now, One school of thought is leave that alone. I mean, you got what you want. Perfect. The other school of thought, which is a little riskier, but there could be a higher reward, is you go to town on this guy and just have him help you, agree with you, and light the whole DA's case on fire by having him in excruciating detail talk about the taillight and this and no pictures and all this and all that kind of stuff. But I don't know what the thinking there was, but the testimony was actually good for the defense. So it's a totally legitimate strategy to, if that comes out, you just leave it be. Now, perhaps the better question is, why did the DA call him as a witness? And I would expect they probably won't this time around.
Be interesting, huh?
Yeah.
So what do you think the defense will do? Do you think they'll call him? They have to then, right?
I don't think they have to, but I mean, if the testimony is that the right rear taillight had a crack, like one, or whatever the language is, you know what I'm talking about, has like kind
I think it
of
was
one
cracked,
crack. That's very different than the famous picture 3 days later from the Proctor crowd about what it looked like in the Sally Port. So, yeah, I think that's probably worthwhile. The question then becomes, do you show them the famous picture from the Sally Port and say, take a look at that? Is that what you saw? Now, if the guy says, hell no, you're done. I mean, the DA is cooked, right? But if you don't know what he's going to say, I mean, look, he's an active duty cop, so it is complicated. Even if his testimony is helpful to the defense, he's still a police officer on duty, like now, active duty. So will he, speak to them? Probably not, right? I mean, they probably won't let him. You just kind of have to go by feel. So it'll be interesting. I don't know, but based on what he said the first time about the condition of the taillight versus everything else, I would not be surprised at all if they do not call him. I mean, I probably would. He's not going to change his testimony. I mean, that's the beauty of the retrial that, favors the defense. You know what he's going to say. He's not going to alter that. Okay. He's not going to say, well, I, made a mistake. Actually, it was shattered in all over the place and, sorry, got it wrong. I mean, he's not going to do that. So I think the risk of harm is less, but then if they call him, now that Brennan can cross-examine him, which, that becomes the risk assessment for the defense is, do you want him to do that? So, it's kind of complicated.
It's like a game of chess in a lot of respects. All this, these little moves, like who do you put on the stand, who do you don't? There's been a lot of interest in finding out which prosecution witnesses maybe don't want to testify this time, because there's been some defense filings that indicate they're looking for something on that. Could that? I mean, do you? What do you think? Do you think there's anybody on that list that doesn't want to testify this time?
No comment.
No comment. Oh boy. I'm wondering who it could be. I want to know what the chat thinks. Who do you think Mr. Bederow might know info on that he doesn't want to say?
I didn't say I knew anything. No comment.
I know you didn't say that. You did. That's true. You didn't say that you knew anything. You said nothing. But I'm reading into it. Yeah, no comment. I read into those no comments. I just look. Someone says Katie. I was thinking Katie too, McLaughlin, but it could be so many people. It could be one of the family members. I don't know. It's funny. Someone said Higgins. Katie's come up. Higgins for sure. I don't know. I don't know. I think Higgins is going to testify. I think Higgins is a professional. I think it's one of the lesser people that's not a professional testifier. That's what I'm going to guess. Since Mark can't talk. Mark, I'm just reading the chat now. We were all reading the chat. Mark's smile is I'm laughing. This is funny. We don't even have to say anything. Just read the chat.
Yep.
Allie's people say, Mark, we can take a break. So what do you think? The Celtics. Let's talk about the Celtics for real quick again. How long is this first series going to last? Is it going to be like over quickly? What's your predictions coming up?
It should be, but if you watch, the NBA or even just the Celtics, so Orlando is a really they're not a highly skilled team, but they're a really messy, muck it up, play a lot of defense. They're just, they bog you down. So they're just kind of not an exciting team to watch, and they win a lot of ugly games. So they can be frustrating to a team like the Celtics, who, wide open shots are their thing, and you have to like not fall for the sauce and get into the muck and get all, the games may not be pretty. Anything more than 5, I think, would be disappointing, but Orlando has given them a lot of trouble over the past few years. Now, those are all regular season games. Doesn't really matter. The Celtics haven't had their main guys, but Orlando is, I think they're probably a slightly tougher draw than Atlanta would have been. They're not nearly as skilled as Atlanta, but they're just, it's like a slog with them.
Someone mentioned the brother's wife. Brother's wife hasn't been seen lately since Aiden reported some stuff about their relationship. If it's her, you think the prosecution would ever, of a defense would ever bring her up and question her? Is that like, let's say she's not on the, I don't know. I mean, I don't know if she's even on the witness list this time. Is that something they would even make hay out of? Would they try something like that?
Whether Paul O'Keefe or his wife did or did not testify in the case against Karen, I think would have exactly 0.0 impact on whether she gets acquitted or convicted. I can understand why the prosecution would want to call one or both of them, but they don't need to. It's really not that critical. And if you or even recall their testimony from the first case, it's pretty nothing. I don't mean that they have nothing to say. That's not a disrespect thing. But in terms of the case itself, they have very little to offer.
Yeah, I think the brother would be more just relevant for the jury, just because there's a human connection.
Mm-hmm.
But yeah, I don't think it makes a difference if she, especially if she doesn't testify.
Yeah, I don't. I mean, again, I don't think it matters.
Now, Trooper Paul, do you think he's going to testify this time? Like you said, they get this other guy. Does that mean they're not putting Trooper Paul? Because I thought he was on the list.
I mean, I think he's on the list. Yeah. I mean, if you're serious as a prosecutor, how do you call that guy?
Yeah.
You're going to argue almost certainly that everything he said is not accurate. Are you going to call him so you're not hiding him? I wouldn't do that. I would say, if you guys want to call this guy and kick him around and say, whatever, if I'm the DA, I'm not calling him to deflate the balloon. I mean, I think like Proctor is a much more interesting, difficult question. Do I have to do it or else? For me, if I'm the prosecutor, Trooper Paul is just an afterthought. I mean, he's just a disaster as a witness, and having the defense emphasize that his theory is not consistent with what the DA's theory is. He's probably going to have the wrong key cycle that the DA claims and all that stuff. His theory of the evidence, just kind of, told me, and pirouetting and bouncing on the ground 30 feet and all of that stuff. I mean, I wouldn't. I don't know what they're going to do, but I would just double dog dare the defense. You want to call them, be my guest and have at them. And, it's just something that they'd have to absorb. I mean, it's not good for the prosecution, but if they have a real sound theory of the case and they think they have the science on their side, and can conclusively prove it, why would you dilute that with your, stupid theory that you're disowning? I just think you lose momentum.
I brought up the children too, those two young kids. I mean, are they going to put? It seems like they're going to put them on the stand again.
Oh, I'm sure they will. Which
Yeah.
is, in some ways, I mean, when you see what they had to say in the first case, you say, why do you do this? I mean, if you
Yeah.
have a smoking gun, or at least what you think is, but having kids who've been through hell, I mean, both parents, their uncle, I mean, you could go on and on. It's horrifying. Never mind the fact the camera's not rolling. It's still a terrible experience to say that sometimes, Uncle JJ and Karen would fight. Okay. They fought a little bit more shortly before he died. Okay. Was there a time that, Karen got mad at me because, I didn't eat a donut on time or something? Okay. But welcome to real life with, parenting or unmarried people that are trying to parent, and the kids are, I don't know what they think they're getting out of it.
It seems really. I mean, I think that there's maybe that human element again. They're trying to, but I don't know. There's not much. It seems like to put those kids through that. Just
They didn't have. I mean, but my recollection is they didn't really have. I mean, obviously they're sympathetic. I mean, they're kids who've been through hell, but saying that they would argue and there were good times and bad times, and they started fighting at the end. Well, we know that. I mean, that's obvious. Like, there's other evidence of that. But to me, this is like similar. I mean, I would trim the fat.
Yeah.
Don't call them. So. Don't call anyone, from the vacation.
No Aruba people.
None of that. No Trooper Paul. I mean, if I'm them, if I have the science, I mean, I don't know that they do, obviously, but if they think they do, then they ought to streamline the case to that and just vote. I mean, if they've got her dead to rights, if that's what they think this is all about, then they ought to do that. But the reality is they don't, based on their own conduct, because they're obsessing over, Karen's admittedly ill-advised statements. But those ill-advised statements are not going to be the difference in terms of her getting convicted or acquitted. It's just, they're not. I mean, they're not that powerful. They're not a great look, but that's not going to get her convicted because, you don't like the way she came off, or, whatever she said at any given time that could be like half of 1% different than another time. So to me, if this was an open and shut science case, they wouldn't be talking about Aiden and her consciousness of guilt, all this other stuff about her statements. They would be talking about science, science, science. I mean, they would be doing, it would be like the Jesse Pinkman argument, right? Science, bitches. That's it. That's what he used to say, right? And that, I mean, if that's what it is,
Breaking Bad.
That's what it is. That would be a strong point.
We get the same question from Kathy and Tiff. They're saying thoughts about Brennan wanting to have people read messages or read the text, says Kathy. Yes.
I think it's a joke. What are you going to do? You're going to have a witness on call who's going to reappear 7 different times throughout the case, now playing the role of Karen Reed is, so no, I think it's ridiculous. And I agree with Alan's point. The guy who found him, who found the data, should report what the data is. And let's not run the risk of anybody overemphasizing, underemphasizing. I mean, if you want to have the person who's on the receiving end of the messages, like, I mean, if you want to really go through the process of listening to Higgins read messages for 40 minutes like he did the first time, I mean, I guess you could allow that. That's, I mean, they're his messages. But the idea of bringing in these other people, male and female, to read them, no. Let's have the guy who found them. And it almost makes me wonder, are they trying to, like, stick Guarino in bubble tape and wrap him up and hide him away somewhere, because have him, if he found him, let him ream him, unless they don't want him to. I don't see the need. I don't know what it accomplishes. I don't need a man and a woman to do this. And again, it's going to take longer. And no, I mean, the judge has the discretion to do it. I would object, like the defense did. I mean, and she'll do whatever she's going to do, but I would object.
What do you think about this time? I mean, I know last time you thought it was either going to be a hung jury, and I know we haven't heard even opening statements yet, but what's your feeling? You either felt hung jury or acquittal last time. You haven't changed at all, right? I'm guessing you feel the same way, or do you feel even more? I mean, I think you do, but how are you feeling right now?
Well, I mean, I believe she'll get acquitted, because I think, based on, what we've seen put out at the first trial and what's been put out in the public record now, there's just there's no proof beyond a reasonable doubt. And people say, I think she did it, I think she didn't do it. Or they say, I think she'll get convicted, or I think she'll get acquitted. But the way lawyers talk about it is, I think she'll be acquitted because there's no proof beyond a reasonable doubt, and here's why, and dig in. So every time, the prosecution says, well, like, for example, she said, did I maybe hit him? Did I do this? And she's on TV saying that, and people cite that as compelling proof. Okay, that's a small piece to your puzzle, I suppose. But how the hell are you getting over the arc of science that says it's a scientific impossibility? That's our opinion. How are you getting past that? How are you getting past the fact that, your theory is that John O'Keefe got hit by a car to the point of immediate incapacitation and just catastrophic injuries to his back of his head, but has no real injuries that traditionally are, coincident to a car accident of that nature? How do you get past the fact that your lead investigator is a dirtbag who, that's no longer opinion, that's actually essentially a finding of the state police, who terminated him for a number of reasons, including his likelihood of actual bias in the very case in which the defense is arguing the cops framed her. So, how do you get past that? And it turns out that he's the guy with his partner who probably lied about the inverted video, and you're going to take their word that they just happen to find taillight pieces over and over. And you say, yeah, but come on, why would the taillight pieces be planted? You go back to the ARCA people. That tells you how. It couldn't have happened that way. Then they had to have been planted. I mean, if, you don't have to be like wild tinfoil hat conspiracy guy. If the car accident didn't happen, then how do they explain the 40-something pieces of taillight? There's only one explanation if there's no car accident. Somebody put it there unnaturally. And, you have a disgraced state trooper fired for bias, and his partner, who probably lied about the inverted video, who claimed we just found it day after day after day, and then we left it, not in the evidence locker. We had it for a month or two. We just, with everything else, you have these people in the house who are, I think we said this before, probably had the only example of a butt dial conversation in U.S. history where somebody, butt dials someone and the response is to butt dial them back a minute later. I mean, that's never happened. You have all these Jennifer McCabe butt dials. You have the battle over this Google search. I mean, you could go on, and you say, okay, what is the proof beyond a reasonable doubt that's going to dilute all of that to the point where I can't even come up with a reasonable explanation for her possible innocence or not guilty? And it's not going to be because she gave, not a great interview to HBO. That's not going to do it. So I don't see how you're ever going to get 12 people who would ever. I mean, the biggest concern I would have is the way they did jury selection, which was, I'm not saying it's corrupt at all. What I'm saying is the manner of jury selection is awful. To do it one at a time without seeing the whole big board and without knowing how to line up your peremptory challenges strategically, by doing it one at a time and getting so many jurors that they got in the first few days is also another tell. That's telling me that the judge is not giving them what they want when it comes to striking people for cause. That she takes a very, liberal view, if you will, of this can be a fair juror, and you're going to get stuck with some of these people because you're not blowing out, 15 peremptory challenges in one day. So
That's what I worry about.
that's the biggest concern I have.
Selection. Yeah.
The manner in which jury selection was conducted is really awful to me.
That's the worry. It's about the jury more than anything else. Even though the judge, I feel like, is against them too, and they get the better legal team, but there's a lot going against them. One thing we haven't talked about tonight, I wanted to talk about, was one of our favorites. The thing that kind of brought us together in the very beginning was this woman. She's an attorney. She's one of Massachusetts' finest, apparently. We call her Wacky Wendy. Did you see her latest theory? She posted this long. She solved it. Thank God we have Wendy. She's like Columbo.
Well, she's not. Well, wait a minute. Let's not offend Columbo. Columbo's. I would trust a TV detective.
Harry Mason. Yeah. I don't
know. I did see her latest theory, and what's great about, you could go on for hours with this nonsense, but she speaks. She's like a Sith Lord. She speaks in absolutes, right? Everything she says is absolute. So she decrees this is what happened. And she's stating it as this is what happened. I don't want to hear it. There's no wiggle room. This is what happened. And the humorous part of that in the first instance is, but she's done that by my count like 4 or 5 times in the past few years and changed her version of events every single time. I remember the plow scratches, and all of the other stuff. And then you can't divorce yourself from Duke Lacrosse. Just how do you do it? That the jury should presume guilt when the defendant doesn't testify. Her wishing or laughing about hoping that Karen is subjected to sexual mistreatment and, misogyny in prison. This, of course, coming from a self-styled feminist women's right advocate, wishing or laughing at, sexual assault of a woman. You could go on and on. So you have to start with she's just a joke and has no credibility and is like a cartoon character. And then if you're willing to even continue knowing all of that and okay, let me dedicate a few minutes of my life to read this. This latest one it's pretty out there. We've laughed about the Island of the Misfit Toys, but this is an argument, and he took two glasses because she's such a raging drunk that the way for him to woo Karen out of the car, apparently,
get the booze out
of the car. The Pied Piper, if you will, is to say, I have your old drink from the waterfall. You want
a cheeseburger for me. Grab the cheeseburger and I'll follow you.
And so that's, allegedly going to lead her out of the car. And then I guess when that doesn't work, what she's going to do, and all these people are noticing her, by the way, and they notice the car creep up. So she leaves that part out of the story. According to Jennifer McCabe and Matt McCabe, they would be seeing this. And according to her, this would be the same time when the Nagel and Mixon and D'Antonio or Dean, whatever his name is, when they drive by, which doesn't match up. So she's not even marshaling all the facts. She's just spewing nonsense. But the idea that what happened was that he got so pissed off that he what did he do? He like threw his shoe, or he lost his shoe, and then he threw a glass with his left hand. I'm going to assume he's right-handed, and then he threw a glass, and that's how we account for all this. And then he bent over to get his shoe, and she said, I'll show you by backing up, but not. I guess she's admitting she's not guilty of murder under the Wendy theory, and then somehow hit him. But then after it did that, although she didn't mean to do it, her reaction was, well, I better get the hell out of here, and just leave. Nobody sees any of this. This is whatever comes after delusional. That's what this is. I mean, this is just nonsense. And when, if some people were speculating, this is their new theory, that can't be the case. But the problem is, when you're the prosecution, you have the burden of proof, and you need to have answers, and you need to be credible, and you need to be the one who has facts, not speculation. Okay. And this is about as speculative gobbledygook nonsense that would require so many assumptions that you would just have to like suspend reality to find. So it's ridiculous on that level. But the problem is, they have the burden of proof. And I mean, you probably heard me say this before too. If you have the burden of proof and you're the one who is speculating, well, it could be this, and then it might've been that, you need to like tap out and go home, because you can't win with the burden of proof when you're claiming that the science is going to prove this, and you're down the rabbit hole talking about, left-handed throws of luring her out and this and that. I mean, it's the island of the misfit toys. What do you expect? I guess it's just, I don't think the DA's theory will be this. They can't be, there's no way this is their theory. If it is, they should dismiss the case tomorrow.
So that'd be nice.
Well, they're not going to
save
do
us all the time. Dismiss it, Hank. Just dismiss it. Get yourself out of the jam. You made enough money.
Yeah. Well, I mean, it's going to be more. I mean, and again, there's still the whole question of, what are the taxpayers? I mean, this is going to be a problem for Morrissey if he runs again.
How much money they're spending on him.
Point, he's going to be asked by somebody, and stop the gag order nonsense. You're going to have to answer this question, okay, about why you're not going to pay $250,000. You're going to pay probably $500,000 or more. You've got 2.5 months of trial where this guy's going to be working 17, 18 hours a day, every day. And you're paying your own employees, and it's all taxpayer money. And there's got to be a rationalization for this. I mean, you have a big office, relatively speaking. Why can't your people do it? And somebody at some point is going to have to get an answer. And ultimately, the voters are going to be the ones entitled to that answer, because why are you paying for this? I mean, it's ridiculous. And that's not Brendan's fault, by the way. That's totally nothing wrong with him. This is a DA problem. And you have to bear in mind, I'm spending probably $500,000 on this. Okay. I gave Mello all the money for that. I'm giving Cosgrove, who's a very nice man, all the money for this. I'm paying special prosecutors out of the wazoo. What does that tell you about the problem in this county, where you can't have anyone prosecute in your office? I mean, you have, at this point right now, discounting Lally and McLaughlin, who really don't count. I mean, they're just sitting there for all intents and purposes. You don't have a single prosecutor in that office who is prosecuting Karen or Aiden. But you're paying for all of it, and you're paying extra.
Paid a lot on a premium. I mean, I imagine we've had the DA candidate come on the show. She went on Brian's show. It seems like she's starting to do some campaigning. I'm noticing that she's been going to a lot of the local town events and that type of thing. I have a feeling she's going to make that the cost. It seems like she might make that a campaign issue, maybe.
Well, I think that's a common sense campaign issue, but I also think, you need to be loud. I mean, you need name recognition, and I mean, when Proctor got fired, I mean, I don't know if she even gave a statement or not. I think she
Oh,
probably
she
did,
did. She
but
did.
you
We
might want,
posted it.
you might
She
want
didn't do video or anything, but she
hey,
she did send out an email. We posted it up. She had a
well,
good statement actually.
you're not winning elections by campaigning by email. I can tell you
Yeah,
that.
that's true.
And I'm not a campaign operative, but
Uh,
and I mean, there's a whole at some point an autopsy on this whole case, and assuming she gets acquitted, um, the real question is if you really want to draw a line in the sand and say what the hell is wrong with this office and why do you need change, it would have been when the TUI materials came out. That was the chance for them to have a mulligan when they got the ARCA report to at least take a pause and reevaluate and be professionals. And they didn't. They doubled down and then went to court and said, there's no exculpatory material here. So this is nothing. That to me is the moment when you knew this office is gone, it's lost, and that there's no coming back.
One more question tonight. It's about ARCA. Couple of people have asked kind of the same question, but it's a little bit different. So I'm going to post them both and have
Okay.
you answer them both. Can ARCA disclose that they were originally hired by the feds? I wonder, because they just blurted it out. Would that be a mistrial? The other question is, why doesn't Bev just do a jury instruction that states ARCA was hired by a federal agency to look into the SUV as being a cause of the death of John O'Keefe? You are not to opine as to why they were asked.
I mean, the judge's reasoning, which and I've always told you this, I can't tell you it's that flawed. Although they don't have a constitutional right to a fair trial, you don't want to do anything that could be perceived as prejudicial overwhelmingly to one side other than the other. You have a jury who's going to be determining whether Karen is guilty as being prosecuted by, essentially the DA's office, the Commonwealth, whatever you want to call them. And then the jury's being told a higher authority is looking into this. And by the way, they just happen to be the ones who hired the witnesses, which are going to form the cornerstone of the defense. So the risk is that the jury, I mean, obviously, if you're pro Karen and not a lawyer, you don't really care about any of this stuff. But the risk would be that the jury is going to say, what are we doing here? Like, this is crazy. Like, we don't want that. This is nuts. So now, if the judge did allow any of this in, then she would also have to allow the prosecution to elicit that nothing came officially. Whether people believe that or not, I'm not getting into that, but it has been stated publicly, right? But not everybody believes that for some reason, and the feds have never said it themselves. So the easy answer for the judge is, I don't want any of this, but she's got to allow them to establish that whoever hired the ARCA people was a government agency that has no relationship, affiliation, association, or anything to do with the defense, whether it be government, private, insurance adjusters, this, that. Like, it's got to be more. It didn't come from us. Now, Brennan is going to dirty the waters. Say, oh, but they paid $20,000, and the guy had the temerity to eat lunch across the street where the defense goes. So clearly, they're biased. So this can get messy, and if Brennan goes too hard, then he just may open the door to the argument by the defense to say, well, now we have to tell them he's gone too far and is misleading the jury. So this is messy. Now, the reality is most lawyers would never cross-examine these guys on getting a $20,000 expense check after the trial when the defense didn't even know who they were when they made the opinion, and their bills are probably in the several hundreds of thousands paid by the feds, but they sent a bill after they testified to the defense for trivial expenses and they paid it, and therefore they're biased. I mean, that's a pretty silly argument or credibility attack. I mean, that's just not impressive. Nope, you went
Shows you
silent.
how
I knew
weak
it.
their case is. They have a weak case. I mean, that's it.
I mean, unless they have, a hidden smoking gun, obviously, who knows? You don't know what they think they have or what they don't have. But based on what you've seen, I mean, I don't see any reason to think that there's any way to believe that you're going to get 12 jurors who are going to say, again, beyond a reasonable doubt. And, people need to understand that if the jury is charged properly on the definition and the lawyers make it very clear why there's reasonable doubt and talk about these things, that if you said to someone, what if you think someone is probably guilty? That's reasonable doubt, even though you think they're probably guilty. That's not a Karen thing. I'm talking generally, like the whole concept of reasonable doubt. Probably means I'm not sure, but I think they are. That's in the reasonable doubt area. So they don't have to believe that, Karen is a nun who should be treated as such and be given an apology when this is all over. They don't have to like her. They just have to believe that there is a reasonable doubt, even if they think, well, she might have done something, but I'm not sure because of this. Then she's walking out of there. If you get jurors who understand that concept. But the best way to make the jurors understand that concept is you got to pound it home in summation.
Hopefully that happens. We're looking forward. Anything else you think that we should be looking for maybe in the second trial? Anything different you think this time?
I mean, I think the trial is different, obviously, because there's different personalities involved. But I think there'll be a little more rhythm, but in this particular court, there are a lot of interruptions. It's just the nature of the beast. There are all these sidebars. There are, there's just very little flow and cadence. So, I think you're still going to see some of that. I think just the biggest difference will be you're not going to see Lally. So it's going to be more effective from the prosecution. I mean, I'm no doubt that the opening will be the exact opposite of, this witness is going to say this witness will say that. And then, after you get through all the witnesses, say that's why she's going to be proven guilty. I mean, you're not going to get that. You're going to get a much more refined, better opening. But I also think you're going to get a better defense. That is, I mean, I don't know this, but I would assume would be more focused on how you take the jury by the hand and lead them to the only conclusion, which is there's reasonable doubt because there's no evidence that Karen did this. I mean, there's no car accident. So you don't even need this third party thing. I mean, really, the argument becomes, I can't tell you who did it, but I can tell you who didn't based on the evidence, and it's her sitting right here, Miss Reed, right? And I think if you connect those dots that we talked about earlier, but you start with the premise of no car accident, then what does the glass on the ground mean? What about all this? What about Proc? I mean, the only conclusion that you can get from that is something is off here. And that, to me, appears to be an open and shut acquittal based on that kind of analysis.
I saw kind of a good question, but it's so hard to catch them sometimes because the chat moves so quickly. So I'm just going to paraphrase it. They want to know if the defense attorneys could say that they're doing this pro bono.
No.
Is that possible that they could actually use that as a?
No, it's not a pro. No, that's a way to inflame the passions of the jury with non-evidence, and the risk that is that they remember the credibility of the lawyers is not literally an issue. You can't give unsworn testimony. The lawyers' opinions are meaningless. They can't say, I think this. The risk is when if they were to say we're doing this pro bono, they're telling the jury their personal opinion. I know she's innocent. Okay. And to tell you that, I'm willing to do this for free. Now, the fact of the matter is all the lawyers are doing it pro bono because they strongly believe in what they're doing and they believe in Karen's innocence. And that's powerful. I mean, you don't see that, and, a lot of people did it. I was going to do that. So you don't see that. And it's a long trial, by the way. That's like, so you don't see that often. However, in all fairness, that's not something for the jury. And that would be sanctionable if they did that.
Yeah, they would get in trouble if they brought that up.
Yeah, no, that would be something that is way out of bounds.
I said like 4 questions ago, last question, then I got one more, but this will be it. With ARCA, because we did ask this question earlier. I'm not sure you quite answered because we threw like 5 of them at you about ARCA. But this one was, if ARCA, like if they actually said like, let's say they were answering a question and they brought up that the FBI hired them. Are they told as witnesses, you can't talk about this, right? They're told that. They're instructed, I'm guessing.
So
what would happen if they ever brought that up?
Well, it depends. The party calling them, prepping them would absolutely be expected to tell them, we can't say this. And if they didn't, or alternatively said, I can't tell you this, but that, and it came out, you'd get in trouble. That would be unethical. If the lawyer, if the witness just honest to God screws the pooch and messes up and brain farts and says it for whatever reason, the judge would strike it, instruct the jury, not be happy. There's probably little else you could do. I mean, I don't think you're declaring a mistrial on that. If it's a true slip up, if it's on purpose, that's a problem.
Excellent. I want to thank you for being here tonight, Attorney Bederow. Anytime you come, we get excited. Everyone's excited. There's a buzz in the chat. I just love when you're here. It's such a good show. I want to thank you again for being here. Let us know when you're back around too. We gotta do that. People are asking about Mazza tonight. Mazza can't do shows right now. He's just got some stuff going on, fortunately. But we miss him. He was watching tonight, and we gotta get together, the 3 of us. We do that soon.
Maybe we'll see what happens on Sunday. But remember, Celtics playoffs, no dice playoff games. That's full focus on the task at hand, which I assure you is not legal work. It's winning an NBA championship. We know that.
It's the most important thing for you.
And if they get bounced early, then, that takes care of that. But, we don't expect that.
Awesome. I thank you again so much for being here. Again, everyone knows where to find him. He's on Twitter, X Bederow, at Bederow Law. He's got a website, BederowLaw.com. Definitely hit him up there as well. I want to thank you, Attorney Bederow, and we'll be talking soon. People want to know. People always want to know. Are you going to have Mark Bederow on when the trial starts? Yes, we're going to be inviting you on, and we're looking forward to. You have any other upcoming shows you're doing? Because you do a lot of other guest shows on other shows as well. Anything planned right now?
No, right now, no. No, not at the moment. I started using for the first time in years my Instagram again.
Oh,
there you go.
On Instagram now, he's branching out.
I'm trying to become, like the cool kids and move away.
You're also on Facebook. I never mentioned that one because I follow you on Facebook too.
Yeah,
we're friends now, I think.
Yeah, but no, that's what I'm told you're supposed to use for pictures of dogs and kids and that kind of stuff.
So you go on Facebook for you putting Instagram? Is you doing the dogs and the kids on there too, or is that like a legal one? How's that work?
No rules. I'm not whatever. No guardrails.
No guardrails.
No guardrails.
We have some guardrails on the show when we're with you. It's funny, but it's I think it's interesting. I love to kind of push the guardrails. Where are you going to stop us?
Well, it's been a weird trajectory in this, for the last year or so in terms of roles and involvement and all that. So, you just have to stay, guardrails. Don't touch the third
guardrails. We all have guardrails in life. You got to have some guardrails. It's good. That's what we do for dogs. They want to know. They want to know what the rules are. They want to please you. That's all dog behavior is. It's like humans. They want to know what's your Instagram handle, Mark. That's what Karen Kruger wants to know.
I don't even know. It's M Bederow.
Bederow. You can find him. That's awesome.
Very original, as you can see.
I'm going to look for you.
Okay.
For you on Instagram too. Thank you so much. And the people were asking for Lola and Winnie tonight. They're
Uh,
not here. Where are they?
Lola is passed out on the couch in the
Oh,
home office, and Winnie is, I'm assuming, in her house, and off the dining room. She likes her doghouse.
oh, I know. My dog, he loves the doghouse too. Some of them just they love the little
Yeah,
house. They love
she
it's like their cave. That's what their biology is, to hide away in the cave and they come out and they hunt. You know what I mean? So they love it. They love the small
Yep.
area. So my guy, he's been I don't have him down here tonight, but like lately when I don't let him down, he gets mad. He wants to come down and go in his little kennel and just watch me do my show.
Yeah.
So they love it. Awesome.
Yeah.
I'm so glad to hear Winnie and Lola are doing good and having a good night. Thank you so much, Attorney Bederow, for being here, and we'll catch up with you soon.
Okay. Take care.
Go Celtics.
Go Celtics.
That was Attorney Mark Bederow. I want to thank him again for being here. It's always fun. Always a good show when he's here. Always good. And you might have noticed we like kind of I just like to turn the super chats off now. So the questions don't come in through the super chats. I don't think it's mandatory. We did have some people doing the donations through the becoming a member, which I appreciate a lot of them. But then I noticed some people were trying to ask questions through them. We're not doing the payment for question type thing. It gets too carried away when Attorney Bederow is. And so if you ever want to ask a question when he's on with us, just post it in the regular chat. And I know it's hard that we don't see all of them because there's so many of them. You just keep posting it. Just keep posting your question until we see it. Because I am looking. I do star them sometimes, but like there are a lot of comments that have come through. But I want to thank everyone who was watching tonight, everyone who sent questions, everyone who did the membership too. Thank you, Deborah. Thank you, Erica Madden. Oh, she's a jerk. I love Erica. She raises a lot of money for Karen Reed. She's awesome. Star Drive In. Check her out. I want to thank Romy. She's been a member for a long time too. I want to thank Scooter54. Jen O, our moderator. She's awesome. Thank you so much, Jen O. And I see you. I want to thank you too. And good U.S. citizen. I want to thank her or them. Sorry. Stephanie. I want to thank Stephanie. She's a moderator. Thank you so much, Stephanie. And Stephanie bought gifted 20 Young Jerks memberships tonight. She's awesome. Thank you so much for doing that. Post-menopausal New Hampshire woman. Thank you so much for becoming a new member tonight. I do want to close. I want to play some Hank Brennan tonight from today with his Turtle Boy motion with that Mark Bederow was a part of today. He wrote the motion. I think Brennan lost. Brennan lost a lot today. Oh, that's what we're gonna close out the show with. I got something I want to put up though. There's this guy who's been using. I know who. I'm pretty sure it's funny because people tell me they think they know who it is, but there's been a guy who keeps creating all these crazy accounts to post. He gets blocked and then he posts the same comment over and over again. So I figured I posted on the screen because I think people already have their minds made up. People in the know on who this might be. I think I might know who it is. But I'll just post this comment tonight and I'll respond to it if you don't mind at the end of the show here. Ronnie the Juror says, Young Jerks, you don't mind collecting money, but you have been to 0 standouts. Why? All right, first of all, I don't mind collecting money, actually. That's part of life, right? I mean, don't we all have to collect money, work? But it's also not like the big thing for me. Like I started this show over 10 years and never made any money. And I still did it because it was what I wanted to do. And it's going to continue whether there's money here or not. But that part about having been to 0 standouts is not a fact. That's not truthful. That's a lie, actually. That's erroneous. And I don't know why you keep posting it. Because I've been to a lot of standouts. I've been to Woburn several times. I've been to the Dedham Legacy Place standout. I've spoken in front of the Canton Police Station, a standout. I've gone to standouts in the city of Salem and Danvers, Massachusetts, and Peabody. So I'm not sure where you're getting your information. It's weird that you're so obsessed that you create multiple accounts to post the same comment over and over and over again, but you don't have your information correct. It's kind of strange. So he says, you are just making money off of this trial. Zero standouts. That's not true. Young jerk. Shame, shame, shame. And I also say, I started doing this before there was any money involved. I was one of the OGs. So I don't know where you were. All right. Let's leave the negativity. It's a McAlbert. I'm not sure. I think it's someone else, actually. There's been a lot of bullshit going on. If you guys can look around, there's been a lot of it could be somebody like that, obviously. But yeah, I mean, there's a lot of kind of, when people see you rise, they get weird. Let's just put it that way. They get jealous. Something that I didn't realize how it would be like this, honestly, until like a year into this, because I've seen it over and over and over again. The people you don't expect, you're like, holy shit, they're jealous of me? Of me? I walk dogs for a living. Isn't that cute? Like they're jealous of me. Can you imagine what Turtle Boy gets? When they're jealous of me, can you imagine what Turtle Boy gets? That's what I always think. Like, if this shit happens to little me, humble me. It's funny. So it's just that's what it is. It's just people get jealous. They get weird. He's making money. Oh, he's got 40,000 subs. Oh my God. Like who? It's like the people that get all upset about when they don't get invited to a party or some shit. I don't care about that. I don't care about any of it. You will never see me complaining I didn't get invited to a party. Usually I'm like, thank God I didn't get invited to the party. Now I don't have to say no. You know, I'm a homebody. I like to stay home. And even though I like to stay home, you know how many times I've been to court and, like I said, going to Dedham, going to Canton, going to Danvers, going to Peabody, going to Woburn. I'm a homebody. And how many places? That's probably I wish I could say I've gone to that many rock shows this year. You know what I mean? Like I don't go out. Like that's my life actually. My girlfriend will say like, "Geez, I wish you did as much with me as you did with Karen Reed." I mean, that's the reality of my life. So when they come at me like that, it's just funny. Like, dude, been my whole life. I invested a lot into this. So, you know what? Let's just finish the show. I'm very thankful. And you know what I'm very thankful for is all the ones who are watching and loving me. I'm thankful for you that you watch and you support me. Even when I'm sick tonight, you're sticking with me right now. 4,500 of you watching right now. That's unbelievable. And you know what? That's the thing, Lauren, is I know I deserve it. I do. And I'm not saying like I deserve like, $50 million or to be world famous, like someone way up there, like, that I'll never get to. You know what I'm saying? But I think I deserve this little local mid-size show. You know, I think I've worked hard and I think I've done this kind of content for so many years. Hard work does pay off sometimes. And sometimes it's about being at the right place, right time, luck and all that. But this isn't my first rodeo. This is my first case. There's been so many cases actually. There's a kid named Cammy D who was 15 years old who got thrown in jail in Methuen for rap lyrics after the Boston marathon bombing. We helped get that kid out of jail. There's been a lot of things like that over the years. Yeah, like someone said, and I did. I kind of did find Bederow, even though Rich found it first. The real estate attorney found it first. Wendy Murphy brought us together. I have no qualms about my success because I feel like I worked hard for it. And I know that I try to be as responsible with my platform as I can be. Transparent. I don't try to punch down. I'm not trying to hurt people. I'm just trying to tell the truth and bring good conversations to people that you want to hear from guests that you want to watch. And I think I work hard at it. And I think the reason why people come to watch this channel is because we work hard at it. I bring, you know what I bring? I bring you the guests that you want to watch, right? So they could be jealous. They could. It doesn't bother me at all. I just want to acknowledge them because that person kept posting it. They wanted to get acknowledged. We acknowledged them. I know. I know. I don't need to explain anything except that I'm sick, as you can see, and it's this. It's just allergy thing. I'm going. I gotta go. I gotta go get some Allegra D, the Allegra G24, and I don't have high blood pressure. I saw you all in the chat, making sure I don't have high. My blood pressure is perfect. Every time I go to the doctor, they're like, "Are you a world class athlete?" I said, "Yeah, as apparently I am." They're like, "I like, how do you know?" And they're like, "Oh, your blood pressure and your heartbeat, and you have no fat on you. You're all muscle." Oh yeah, 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 yeah. I'm a world class athlete. All right, I gotta go now. I'm bragging. Did you know I used to play high school football, Al Bundy? I never played high school football. My mom wouldn't let me. She wouldn't sign the permission slip. Thank God we got her to sign the permission slip to let me wrestle. All right, let's watch this. I'm going to bring up Brennan. I want to end the show by bringing up Brennan. I want to thank attorney Mark Bederow for being here. He's phenomenal. He's always so good on the show. I love it. Even sick, I knew I should just sit back and let Bederow go. And we did. We got some spicy Bederow. And you could tell I was excited. I started smiling a few. There's a few times where I'm just like, "Go Bederow!" I just love when he does this thing. He's so good at it. All right, let me get this video up. Let's finish it off with this tonight.
But I think I necessarily would have to delve into issues regarding his open indictments against a number of different victims.
Okay.
And I think there's other information that I can't discuss for other reasons because of court orders.
Okay. All right. Thank you.
I would suggest that the court could take judicial notice of the 16 indictments against him.
So the Commonwealth concedes, and I believe there's a valid Fifth Amendment right. So
I ask that you just allow me to make the representation on behalf of Mr. Carney that he would in fact invoke his Fifth Amendment privilege. Commonwealth agrees to it. I ask that you just allow me to make the representation and leave it there.
oh, sure. Is there any objection for everybody hearing this?
There is. I would like Kearney to consider his fifth.
Oh, I thought you wanted a basis. No, I'm going to see Mr. Kearney here at sidebar with just you, Mr. Bradel.
Thank
And
you.
all recording devices are off.
Thank you.
FTR goes to sealed, Tori and Chrissy. Tori. All right, so Mr. Brennan, I've just had a colloquy with Mr. Carney, with his lawyer present, obviously. I find, and the Commonwealth concedes, that he does have a valid Fifth Amendment right. I find that there's a valid basis for him to invoke that Fifth Amendment privilege, and I find that if he were called to testify, he would in fact invoke that Fifth Amendment privilege. So based on that, he will be exempt from the sequestration order, except as to, and I need a list of the named witnesses who are the alleged victims in the current indictments.
I accept those findings. We will provide the court with a list of the named victims. We also would like to have the court consider the 2 minors in that list.
Oh, yes, I think I did that last time as well.
Thank you very much, Your Honor.
All right, so is that it for today?
Judge, if I may, just for the record, maintain the same objection I had at the last trial. Don't need to make any further commentary
sure.
on it, just in case there's any further action, which I don't anticipate right now.
Okay.
But just for the record, thank you.
Okay. All right, so we're all set until Tuesday, I believe. I'll get
Thank you.
orders out. Oh, stipulations were just given to me. I have not had a chance to read them. All right, this looks like you all made some progress in a way that where the jury will be happy that you've cut down the amount of time that they may be here otherwise. Okay. Anything else today?
The only thing I would ask the court to consider is with regard to the speaker, the reader issue.
Oh, okay.
If the Commonwealth intends to go forward with that, I would ask that that be put in a formal motion so we have something to respond to. I think research on that is in order.
Oh, okay. Sure.
Doesn't have to be lengthy
And it is something that we've done.
right. Understood. I would like to see I'm going to have to look at what the law in Massachusetts is concerning that and what the sort of parameters are.
Okay.
I just think because of the potential prejudicial effect on Ms. Reed, I'd like to have something in writing. That's all.
It is in the extrajudicial motion. If there's something separate the court wants brief, we're happy to do it, but it's already in the motion that we provided regarding judicial statements.
Okay. All right. Thank you all. We'll see you Tuesday.
Thank you.
All rise for the vote, please.
Thank you so much, everyone, for being here tonight. I wanted to let you know that Sunday night, we're going to have Larry from the Sturm Group. He's going to be talking about the Canton police audit. Looking forward to that. I think Peter Murphy's going to be on the show as well. So we're going to have a retired Canton police officer, retired Massachusetts state police officer that works for the Sturm Group. We'll be talking about the Canton police audit on Sunday night at 6 p.m. here. Please come back. Please come back on Sunday night, 6 p.m. I hope to see you there. It'll be a good show. I guarantee you on that. Thank you, everybody. Have a great night. I want to thank our moderators. I want to thank MJ, Stephanie, Jeno, Sarah, and Shaka and Scott McGinnis. I think I saw all of them tonight. Pretty sure. Or at least most of them. In the chat tonight. I want to thank our moderators. We have the best mod team around. I brag about you a lot because I love our mod team. Thank you so much to our mods. We'll see you again. I might do a show maybe Friday night, Saturday morning. We'll see. Let me know if you think, because I'm thinking about playing some video, reviewing some video from the first trial, and I'm trying to decide what kind of video should we review that we haven't. Maybe Jen McCabe, maybe Allie McCabe, maybe one of the EMTs, right? I want to know from you, who do you think we should? We've already done Matt McCabe, Trooper Paul, yeah, maybe Trooper Paul, Higgins, Allie, yeah, McLaughlin. I mean, who knows? Whatever. Katie, what was Katie's last name? I forget Katie's last name. Katie is another one. I'm not sure. What do you think? Who should we review if I do a show on Friday night or Saturday morning? Oh, thank you, Buckwheat. Thank you so much, Buckwheat. Let me know. Yeah, maybe Saturday. Barrows, yeah. There's a lot of ones. Guarino. You guys are giving me a lot of good ideas, actually. We need to pick one, though. Pick one. McLaughlin. Yeah, Katie McLaughlin. I was thinking Katie. I think that would be interesting, but you're right. Maybe Barrows, maybe Colin. Yeah, Colin's another one. Oh, maybe Colin or Higgins. There's so many. Allie, Trooper Paul. But I gotta go. You guys give me lots of food for thought. I want to thank you. Guarino. Yeah, Guarino is a good one too. Somebody should, maybe I should do a poll. You guys decide it. But again, please come back on Sunday night. Definitely. And I want to thank everybody who's been watching, supporting. I really appreciate you. Scanlon. He's on the witness list. Maybe he'll testify this time. That'll be interesting, right? That's a good one to look forward to. All right, I'm heading out. I'll see you guys. I'll see you all. See you later. Definitely on Sunday night. Yeah, I'm gonna lay down. Yeah, actually, I'm gonna get in the car. I'm gonna go to the CVS 24 hours and get some Allegra D. I'm gonna listen to Bederow. Bederow told me what to get. I'm gonna listen to Bederow. Have a great night, everyone. We'll see you soon. Yes, I will. I'll try to do a poll. Yeah, Allegra D 24. I'm going to get some. If I'm not over medicated already. I took some meds like right before the show, but it didn't help that well. Allergies is like a new thing for me too. Like I never used to get them, but I'm recalling the last couple springs I'm starting to get these allergies. It's old age. All right, have a great night, everyone. We'll see you soon.